Hi, everybody. Hi. Welcome. Hold up. Let me make sure that everything is in working order. Welcome. Shout out to everybody in the chat. Thank you. You said I'm back. 5 minutes to go. Does everyone does everyone have something to drink or a snack? Says Steph. Shout out to y'all. Thank you. Shout out to my regular schmegulars in the chat. You guys, we have so much to review and get into. Hey Ronan, how are you? Shout out to Ronan. Everybody come through. Yes, justice for Emmanuel, of course. I'm waiting for people to get in here, y'all, because I don't want to have to like stop and go and everything. Because we got let's see, one, two. So this is the plan. All right, we're gonna talk a little bit about just do a little bit of review of what happened today at the hearing for Emmanuel Haro. Excuse me, the arraignment for Jake and Rebecca Haro. That people have said all kinds of things that were in the court. I found them to be interesting, so I want to talk a little bit about that. We won't spend too much time on that, but for sure, we're gonna talk about that, and then we have to talk about Laken Snelling. Keep saying her name. I think it's Snelling. I'm pretty sure it's Snelling. Laken, we got an update on the infant, and it's a very interesting update. So we're going to talk about that. And then is talk about Alexi Trevizo. Now, you guys know I was multi-streaming today. Never done a multi-stream before. So I was live with the Haro situation, right? With the Haro situation. And then I actually also stream the oral arguments out of the Supreme Court in New Mexico. So we're going to get it. Like, I have not watched the arguments. So I'm like, well, let me react to them live with you guys. It's only about an hour. So we're going to get right into that. And then we're going to go from there. You said, let's see. Welcome, everybody. Welcome. Great timing. Just finished up the trial for the case, and I've been following since 2014. At least one more arrest to go. Venus, are you talking about the Adelson, Dan Markel case? Is that the one you're talking about? Put a one in the chat if that's what you're talking about, Venus Blue. Let me know. Donna Adelson was found guilty. Yeah, I think you guys were talking about the Adelson case. Oh man, that case, it's too I never like I remember hearing about it before I used to love podcasts. I used to love hey Belen, how are you? Y'all said yes. Okay. I used to be a huge like Apple podcast person. This was like before I started my YouTube channel. I remember going to bed listening to podcasts, and I remember listening to the Adelson case. Oh my god. Like they like set up the killing of Dan Markel, their um son-in-law, and it was the she was found guilty. It was the matriarch of the family who did it. Literally. And then those like they had anyways, that case is just crazy overall. I didn't cover it as extensively on this channel. But I know that there was a lot of great podcasts out there that did. Shout out to them. But that was a case. It's a very sad case to know that they did all that to Dan Markel, law professor, a bunch of things, man. Anyways, they basically set him up to have him. They it was a hire kill for hire situation, for sure. But the one that set it up, or at least ahead, was Donna Adelson. But anyways, shout out to everybody. Shout out to everybody. I didn't realize how long that case has been going on. Yes, it's 20. So it was the brother had the trial first, and then it went to Donna. And I think they tried to flee the country. Didn't they try to go to like Thailand or something like that? If I remember correctly, it's been many years, but crazy. The guy was a dentist. And he basically had a dealing in having his, you know, brother-in-law offed. And I don't know how Wendy Adelson is not charged. Like, did they not find anything that she might have had? Was it Vietnam or Thailand? Vietnam. Thank you guys. How is what y'all put a what? Okay, for those that have follow the Adelson case, you guys really think that Wendy is like an innocent bystander in this situation? Miss me with that. You think they're gonna bring her ex? I see, that would be an interesting Wendy's coming. Really? That whole family. Oh, well, maybe we'll cover Wendy Adelson. Okay, maybe we will. We'll see. Okay, we'll see. All right, guys, let's get it together. Let's get it together, y'all. Welcome, guys. Make sure you guys are hitting that like button. Okay, let's start with, why don't we start with Laken first? Okay, now for those that don't know who Laken is, she is the young girl out of Kentucky. Well, I think she's back in Tennessee, but so she was going to school in Kentucky. Sorry, I hear myself echo. So she was going to school in what is it, University of Kentucky, right? Going to school there, and apparently, the roommates found a deceased infant in the closet of the situation of where they were living at. Sounds like she might have been concealing the fact that she was pregnant, although I've been watching a lot of pictures out there, and the girl could not hide that bump. Like, let me listen, Linda. I don't know. For those that said maybe she didn't know she was pregnant, mm-mm, I don't know about that. I don't know about that because she's definitely giving pregnant. She's definitely giving she knew, and or maybe she just, I don't know, man. Maybe she got scared. I'm not really sure, but hold up. Let me pull up some Abby Blabby real quick because she's got I'm like, how do you spell Blabby? How do you spell Blabby? Blab, hold up. Y'all can't spell Abby Blabby. Laken. Anyways, so Laken there's a lot of pictures of Laken out there, definitely looking pregnant and whatnot. People said, well, she wasn't, she didn't know. I don't know, man. There's some pictures out there like, oh, doesn't this remind you of Alexi Trevizo? Lexi, what are you doing, Lexi? I told you about this, y'all. Thank you in the chat. Blabby rabbit, Blabby. Thank you. That sounds like see, here she's not showing too much. So Abby Blabby says photos of Laken Snelling from April. This is April. This is April. Okay. There's a rumor going around that baby was 18 weeks gestation. I'm not sure where that came from because here she's at around 5 months. Listen, but she was not a freshman. She was a senior. So the senior 15, apparently the roommates. Listen, we gonna get into this. So let me tell you, we got a little bit of an update. Okay, let me get into this update. So, the University of Kentucky athlete, she's a very athletic girl, very much cheer stunt. That's what she does. Allegedly placed her dead infant inside of a trash bag, later found in a closet while trying to hide the baby's birth. Okay, leading to her being jailed. That's what we know so far. She was charged. She went to court on Tuesday. She's out on bail of 100,000. Okay, all right. So she's 21 and she's facing charges of a corpse abuse, tampering with physical evidence, and concealing the birth of an infant after her arrest on Sunday. All right. So Snelling had been a member of the University of Kentucky competitive cheer stunt. Okay. On her citation, it says that a deceased infant being located inside of a closet was found. The baby was wrapped in a towel inside of a black trash bag. They said something in that arrest citation that said something to the effect of, like, it was really bad condition or something like that. Cleaning any evidence, placing the cleaning evidence that she used, she actually placed it in that bag as well. So the local coroner's office later said an autopsy conducted on the infant yield inconclusive, listen, inconclusive findings about the baby's cause of death. More tests would be needed. All right? Inconclusive, right there is what the coroner's report says so far. It further goes. Snelling by Tuesday had been released from jail on bond. Okay, so that is what we know so far. Her next court hearing is September 26th. Let's see. So she's supposed to be back at her parents' house. The more serious charges against Snelling are corpse abuse and tampering with physical evidence under Kentucky state law. Both are considered a Class D felonies, meaning people convicted of those crimes in particular could receive between 1 to 5 years in prison, as well as be fined up to $10,000. Okay, so it is not clear on Tuesday if Snelling gave birth, suffered a miscarriage or stillbirth, or underwent a self managed abortion. It is legal in most states, including Kentucky, to self manage your own abortion. Okay. When they say self, I'm not familiar. Let me look at what is self manage. I feel like I'm not familiar with a self manage abortion. Let me just find the meaning of it. It's an SMA. It's when a person ends a pregnancy outside of a formal healthcare system without clinical supervision or support from a doctor. Okay, this can involve using medication. Okay, so you can get the medication from the doctor and then you kind of have the abortion on your own, or other methods like herbs or physical. Okay, I've heard of this. People may choose or be forced to self-manage their abortion due to legal barriers, lack of access to formal care, or preference for greater autonomy in their healthcare decisions. So right now, just so people are clear, we don't know if she miscarried. Okay, we don't know if it was a self abortion, and we don't know if it was a stillborn. Right now, it's completely says that the coroner has ruled this inconclusive. So I'm pretty sure that the more information is going to come out. Okay, let's keep it going because we definitely have some more stuff to review before we get to Alexi Trevizo. Okay, so listen to this. This is, again, we're going to go to Emmanuel Haro. We're going to go to Rebecca in the hearing and what various TikTokers have been saying. Listen to what she just said.
I went in, I walked in,
or what
and
she
Jake
says.
was sitting to the left, like last time. Rebecca was sitting to the right again. Dude, Rebecca was crying. She had tears just like falling down her fucking face while Jeff Moore, her new attorney, was talking to her. She just was like, and she was trying so hard to fucking suck it up. She was trying so hard not to let her. You can tell. You can tell. It actually was real tears this time. The only reason why I think it's real tears this time, I think she's so sad and scared about what's coming next for her. Exactly. Exactly. She's not crying for her baby. Exactly. Yeah, and you guys know that everything I say is factual. It's facts. Nothing is lies. Nothing is rumors. Nothing's made up stories. Everything I tell you is because I seen it with my own two eyes and I was right there.
Okay, there we go. So people are saying that girl was upset. She was actually crying, but I think she's crying because she's actually scared. Not so much for her child, Um, not so much at a concern that, like where this baby's at. Like, you crying for you being in this situation, or you crying because you miss your child, or what exactly? I don't know. I'm telling you, Christy, like, should this not motivate you to just tell what happened? I had a thought. I said, listen, and maybe it's an unpopular opinion or whatever, but let me just say this. If she could just sit there and just like girl, maybe she was going through DB. Okay, the girl did have a black eye. Okay, maybe there were so many things. Clearly, this man has a pattern of behavior because the Margarita Avina, right, the Vanessa Avina's mom, said that he was very abusive and he controlled that Vanessa and whatnot. By the way, I do have the transcripts for that hearing. So that's going to be a separate video. Stay tuned, y'all. You guys know I don't, when I say I'm going to do something, I say I'm going to do it. Didn't I? Did I tell you I was going to do that? Yes, I did. Okay, I do deliver. But anyways, side note. Yeah, so I do wonder, like, now that she's been a couple of days, a week, 2 weeks behind bars, away from, Shrek, the ogre of Riverside. Now that she's been away from him, maybe she's able to talk. You know what I mean? Let me know what you guys think. I cannot wait to hear, says BKV or BKVNYC. I don't know. Let's see. Rabbit says, "You know who I am." That's right, Night Charm. You tell them. My day ones know. All right, let's get into this hearing and just a little recap of what happened today.
Emmanuel Haro. Hello, I'm Angela Chen. Jake and Rebecca Haro have both pleaded not guilty to their murder charges today and for filing a false police report. News Channel 3's Garrett Hoddle is live outside the courthouse in Riverside right now. Garrett, what can you tell us?
Well, the arraignment lasted about 5 minutes in total, I could say, and I can tell you inside the courtroom, you couldn't get a very good glimpse of both Jake and Rebecca Haro as they were being blocked by their attorneys in court. Now, we learned a couple of new things. As you mentioned, both Jake and Rebecca Haro entering pleas of not guilty on those murder charges. We also learned that Jake is now being represented by 2 lawyers from the public defender's office. Remember, at last week's hearing, we told you that the public defender's office said they could not represent both Jake and Rebecca because of a conflict of interest. Now we're learning that a new attorney has been appointed to represent Rebecca by the conflict panel because of that conflict of interest. So in sum, right now we know Jake is being represented by the public defender's office. Rebecca is being represented by Jeff Moore, a local attorney right here in Riverside County. We reached out to both of them after the arraignment today. They did not want to interview and go on camera. But this story, as we've seen throughout our coverage, it's garnered a lot of attention, and there's been several groups right here outside the courtroom today advocating for change and actually making real steps. I want to introduce you to one person we talked to earlier today. Her name is Jasmine. She does this podcast called Murder by Nature, and she's been covering this story basically out here at the courtroom and with the
shout out to Murdered by Nature podcast. She was on our channel. She's the one that actually gave us some information about Rebecca adopted and giving us some family information. Shout out to her. Shout out to the girl.
And Cabazon every day. Take a listen to one effort that she's doing right now to make the world a better place, she says, in lieu of this story.
So we are taking action. We made a change.org to build a registry for child abusers.
Yes.
So we want to make sure that people that do any crimes to child abusers, like any crimes to children that are abusers, they have a registry that they go on, just like with Megan's Law or just like with sexual assault victims. You have to be on a registry where you can't live next to a school. You can't do this. You can't do that. Why are we not protecting our children and doing the same?
Jake Haro.
Ooh. That's a huge undertaking because, like I said, working in CPS 10 plus years, there are privacy laws, there's different things. So they might have to, it's hard to build a registry because it's kind of like, what does that mean exactly? What levels of abuse? You have parents that fall into the CPS system that may never get out of that system. Does that make sense? So I'm curious. I would like to support, but I want to know more.
And I mean, get this, she's not the only one. Jasmine is from Yucaipa, so this story really hits close to home. But we also saw people here from groups as far away as Caldwell, Idaho, advocating on behalf of little Emmanuel. The latest, though, the biggest question is, where is Emmanuel? We heard from the DA's office last week that they have a strong indication of where Emmanuel's remains may be. They also say that
Wim started that Steeler princess. That was earlier in the chat. Wim is so messed up.
they believe Emmanuel died over a prolonged series of abuse caused by his parents before August 14th. We've asked how they were able to come to that conclusion. We haven't been able to get those details just yet. I was also told by the DA's office today that the arrest warrant will not be made public. They believe that is, of course, the judge's determination. So we're
not going to get the arrest warrant, guys.
We're going to continue pressing for that. Meanwhile, a felony settlement conference in this case has been set for the 16th with prelims on the 17th. We'll keep you posted if that changes. For now, live in Riverside, Garrett Hoddle. Back to you guys.
Quick little update now. Of course, they're saying that, I mean, again, this case might actually be heard in Banning. Someone said in the chat the other day that that they were what is it called? Judge shopping. But I don't know, man. It's a lot of, I think, moving different parts and whatnot to this case. There's multiple lawyers involved. I don't know if that's a logistical issue or if that's the thing that they want to do and whatnot. So I do wonder how. I guess we'll find out on the 16th and 17th while these hearings are coming up. But here's the deal, man. This is what I'm hoping for Rebecca Haro. I really hope that she gets a touch by an angel moment and she decides to like actually do right by the situation and just tell the people what happened, man. Tell the officers what happened. Or maybe she doesn't know. Maybe she doesn't know what happened exactly. I don't know. I have a lot of questions. She's sitting there and she's crying and she's upset. The gravity of the situation is real, but you got to say something. You have to say something. Maybe they'll be tried separately. Maybe, well, if they turn on each other, I mean, they have to have separate lawyers. That's for sure. That's for sure. You said, y'all are going on the suit for the. The man shops in the little boys department. Okay, let him be. All right. Shout out to him because he's out there. You said the reporter with the corset. Yo, how am I supposed to be a serious true crime channel when you guys do this in my chat? I don't know. Yeah, and it seems like she didn't have a violent history, so there might be more to her story, but I do hope that she gets I don't know, that she sees through this and she wakes up, you know what I mean? Sometimes that's what it takes. All right, guys. All right. Let's move on, y'all, because you guys are messy. All right. So some of you guys, let me give you the little too long didn't read version of this case, okay? So some of you guys may not be familiar about this case, and I think this is a very important case. I wouldn't necessarily say it's similar to Laken Snelling because we're still figuring out how this is going to develop. But the Alexi Trevizo case out of New Mexico. So Alexi, in January of 2023, Alexi was 19 years old. She goes to the ER because she's got back pain. And at the hospital, she went to the restroom and she delivered a baby. And the baby was later found dead in a trash can inside of the bathroom. Now, mind you, she delivered this baby in this bathroom. There, think about a hospital. If you go to a hospital bathroom, they always got those little pulling emergency things. She was there delivering a baby while staff were knocking at that door to figure out if she was okay. There was an investigation which included the police. You know, there's police body cam footage that's very public on YouTube that everybody can see. But that police body cam footage actually captured the hospital staff confronting Alexi Trevizo. So the argument right now is, what role did hospital staff play when dealing with Alexi Trevizo? Did they violate HIPAA? Okay, there's that. She initially denied being pregnant, but later admitted that she was pregnant. They did an autopsy on the baby, and the death was ruled a homicide because the baby had had air in the lungs. So it was so when the baby was pulled out of that liner, and it's a very frustrating story because you got hospital staff there, right? Has she had a baby this was healthy, whether the baby was crying or not, because it doesn't sound like the baby was. You had hospital staff there that could have helped out and didn't, right? The baby, I'll never forget the interrogation of the cleaning woman that had to clean up the bathroom. She says she found the baby and the baby still had the bag to the mouth, right? Because the baby was trying to breathe. Okay? So that's like, just think of how horrific that would be for anybody to find something like that. Keep that in mind, okay? So then let me break it down further for everybody. So then Alexi was charged with first-degree murder and tampering with evidence. Now, the legal developments from this is that her defense team argues that the baby was stillborn. Prosecution maintained that the baby was born alive and intentionally placed in the trash because she was trying to conceal it. This case in 2023, 2024, especially 2023, it gained so much national attention because this hospital video, the body cam footage, all of it was out there on YouTube. Everybody had an opinion about it. We talked about it. We covered it heavily on this channel, and so many other creators did. There was so much public debate about pregnancy safe havens and rights. It goes into, a lot of people will argue, the abortion situation with this. Everybody's got a different opinion. But anyways, so the Supreme Court was basically approached because the lower court found that there was concerns about some of what the prosecution's evidence and what they were bringing, which is the body cam footage. There was concerns about whether it was admissible, but taking that body cam footage of where Alexe's admitting, or at least saying it wasn't breathing or this child wasn't breathing, is very, like, it weakens the prosecution's case. So they took this all the way to the Supreme Court because the lower court sided with the defense. And so that was what oral arguments were about today. Okay. This was going on while we were covering Emmanuel Haro. So guess what? The Supreme Court actually has a YouTube channel. So I was able to multi-stream. So we're going to watch some of these arguments right now. And y'all let me know what you guys think in the comments. So this is, let's see. Hold up. Oral arguments, State versus Alexee Trevizo. All right. So I sped it up. It's about an hour and 11 minutes. We'll see how much we can get through this. And I might have to speed it up a little bit.
Good morning. We're on the record of S1 SC 40487, interlocutory appeal, State versus Trevizo. We have appellant opening 20 minutes. You may enter your appearance and proceed.
Thank you, Your Honor. Michael Thomas, NMDOJ, Raul Torres, Attorney General for the state.
Good morning.
Attorney General for the state of New Mexico, y'all.
You may proceed.
Thank you. May it please the court, counsel, and attendees. This case, still at the pretrial stage, involves two narrow legal issues, specifically whether the district court's decision to suppress evidence was factually supported and legally sound. The district court erroneously concluded that there were violations of Miranda and of the physician-patient privilege. Many of the court's key findings are either not supported by substantial evidence, or even if they are, do not support any assertedly related legal conclusion, revealing that the district court was mistaken about the applicable law. The interaction of the doctor, other medical staff, and defendant, as well as the police, are captured on the lapel video in the record as Defense Exhibit H from the suppression hearing. A careful review of the video is critical to a proper understanding of the issues, as it undercuts a myriad of defense assertions and glaringly fails to support and outright contradicts the district court's findings, as well as various characterizations in the ruling.
Counsel, I'm going to interrupt you in two things. First, you need to slow way down. Second, I'd like you to address pretty much right out of the gate State versus Ibarra.
State versus
Ibarra. It seems to be a case that answers this question a little bit.
And I'm not immediately familiar with that case, Your Honor. I'm sorry. I'm trying to do my best to answer the question.
Okay, so I'll try and tee it up a little bit for you because I don't want to completely catch you off guard. So this is a 1990 Supreme Court case.
So again, they're this is oral arguments to figure out about the evidence piece. This is the attorney, the head attorney, whatever, not attorney general. I think that's a formal title. But anyways, he's the head attorney of the state of New Mexico. Gloria said, I heard the mother was suing the hospital, the audacity. Yeah, they're suing the hospital. So there is that. Ibarra is the case. Patient privilege. What about the baby's privilege? Says Detroit's. What do you think? If the mother claims she didn't know she was pregnant, then who speaks for the baby? Ooh, bring it. Let me know what y'all think. Please have this argument in my chat. I love it.
And in that case, it's discussing the term interrogation for purposes of Miranda, which seems to be an issue here.
Did the hospital interrogate her? If you've been following this case of Alexi Trevizo from Jump, did the hospital interrogate her? When they asked her, there was a baby, they confronted her. There was that doctor in the white coat who said, there was a baby that was found in the bathroom, and they started asking questions, and Alexi was sitting there, and she was like, it wasn't breathing, no. And then the mama's like, Lexi, what the heck you do, girl? Like, she was doing all that, right? So that's the question. Did the hospital interrogate her when they were asking her questions and whatnot? Y'all, let me know what you think in the comments.
And it says that under Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attended to arrest and custody, that the police should know are reasonably likely to elicit incriminating response from the suspect. So that's that concept. Does that help?
Yes,
Okay,
and,
great.
and I do remember Ibarra. Sorry,
Okay,
I didn't
no.
understand, but then I recognized it was Ibarra, which is cited in the brief.
Yes. Okay. No, that's okay. So I would like you to address
Get it together, sir.
that statement that comes from Rhode Island versus Ennis, but was adopted by the New Mexico Supreme Court.
That's the question. She was never Mirandized before. Therefore, was it an interrogation? That's what they're arguing. Oh, I love it. You guys are here. I love it. Shout out to you, maggots. Shout out to you. Okay. Let me hit play.
Yes, thank you. And I do recall Ibarra in the briefs. Your Honor is right that interrogation under Ennis can be express questioning, or it can be, as Rhode Island Ennis talks about, actions or statements by the police that are, as they say, that the police knew were reasonably likely to elicit an incriminating response. The reason why the state believes there's no interrogation here, Your Honor, is when you look at the video, just so we're all starting from a baseline, the police do not ask her any questions at all. The police do at one point ask the mother, did she have a driver's license? They hand that over. Of course, they're going to run everyone for warrant. It's like showing up at a car accident scene.
We do see that in the video, okay?
But as I cited in the briefs, we all are familiar with cases that say they're asking for a driver's license thing, and that's procedural. That doesn't count as interrogation. So then the question would be, did the police say anything that would be, as Ennis says, reasonably likely to elicit?
Well, not say it can be actions as well. And that's what I want to focus on, is actions, because I get that the police didn't say anything, they didn't ask questions. But here, my concern is that if we only review the video, and that's out of context to what the police have been told prior to going into the room. There's been a report, they've heard from the nurse, probably things maybe the nurse shouldn't have told them, and then they're invited to go in. And so there's action as a result of that that's different than like they just pop their head in, or if the report had just been made without healthcare folks tying the report to this young lady. That
were her rights violated? Was HIPAA violated here? Was HIPAA violated? Listen, people have said that she might get away with this because of this situation right here. This situation right here. Y'all.
That might be different if they were just going room to room saying we'd like everybody's name and information. But here they have this body of knowledge before they walk in the room. And that's what troubles me in this case.
Yes, and I'll do my best to answer. And of course, I know we'll get to the agency issue later, that the other side is arguing that the doctor was an agent. But yes, just strictly actions of the police. And I do appreciate the court's questions in focusing this. We know that it's an objective test for custody, but now we're talking about actions that can be arguably that would have caused or been the equivalent of interrogation under Ennis. The state doesn't believe the police did anything here. I'm glad that the Justice Bacon brought up the question of, well, that the nurse went up and talked to the doctors, the charge nurse went up and talked to the police when they arrived at the hospital. I don't see a problem with that, because generally when the police arrive at a scene, they're going to want to talk to the reporting party. Now, granted, the doctor, whoever it was that called the police, the reporting party here is a little ambiguous. It's essentially the medical staff of the hospital. It's not like a neighbor calling the police on a loud party next door, but the police naturally are going to want to talk to the doctor, the nurse, get a little bit of information before they barge in there. I think the police acted very reasonably here. They talked to the doctor, they talked to the nurse, and I think the police are smart enough to realize that just because this charge nurse is telling them this, that, and the other, that's just for the police officer's information. The defendant didn't even know what was being told to the police. So my point being that nothing that was said to the police in the hallway would have even been known to the defendant. So going back to the
Counsel, that's always the counsel. My concern here is, and I'm curious, why did the police feel like they needed to go in the room with the doctor while she's talked about the defendant's treatment? Because the doctor told the police before she went in the room, I need to go tell her about what her condition is and what we need to do next. And then she says, will you come with me?
Yes, I'm sorry, I slowed it down. I know it's there. I speeded up to 1.25. the judge so this is a panel of judge and they're having this argument. Okay, you said the police were there for the investigation, so HIPAA was not violated. As a mandated reporter, HIPAA goes out the window if there's an offense committed that needs to be reported. I'm telling you, man, Alexi Trevizo's case is about that. Like, literally, it's gotten to this point where there was a professor. Okay, let's get into this. I did a video and some of y'all did not watch it. There was a professor, okay, who she's a professor and she's also for the ACLU. And so she wrote she's done research, and she's a law professor. She's done research about medical staff in the law enforcement intervention and when they cross the lines. She gave a very compelling argument about the fact that Alexi Trevizo's HIPAA was violated because the medical staff acted like basically arms of the police instead of prioritizing her health. That's what the argument is. Yes, this is Supreme Court live video. They have a channel and there's a lot of cases that they hear and they let people watch.
I find a little strange, but why did they feel like it was appropriate for them to go in the room with the doctor to discuss treatment?
Well, I would say that at that point, they clearly had reasonable suspicion, probably more than that, given that the medical staff was, and I'm doing my best to answer your question, the medical staff clearly knew that the only person that had been in the bathroom during that entire relevant time was the defendant. This was not going to be a whodunit. So you're right, the doctor does say to the police officers, look, I need to tell her what's going on. I got her accepted to Loveless and Roswell. I need to tell her what's going on. She's bleeding. I need to make sure she's stable. The doctor simply says, does one of you want to go in there with me?
No, that's not what he said. She says, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot. And she immediately asked the officer, quote, if one of them is willing to be part of the conversation, and invited the officers into the hospital room, and they both agreed. So that's, I want to be clear on what the facts are. And she says, I want you to be part of the conversation. And they both agreed. Secondly, and maybe this is another way of asking the question that Justice Vargas asked, is there any medical reason for the officers being in the room when she's confronted?
Ooh, I like this. I like the conversation, y'all. Like, this judge is like, no, listen, I have to say something. Oh my God. I love it. If the baby never takes its first breath of life, fluid will still be in the lungs that would not be, I can never say this word, I think it's asphyxiation, right? And would be considered a stillborn. Thank you, Kim. Who's Kim's like, wait a minute, whose case are we? This is Alexi Trevizo. They had oral arguments. We talked about Laken Snelling earlier. Kim, shout out to you. Yes, and by the way, y'all, do me a favor and drop some hearts for Last Ronin. Welcome, Last Ronin, to the Wrench Rabbit Club. Thank you, Ronin. Ronin is amazing. Thank you. All right, hold up, y'all. Hold up.
Is there any medical reason for inviting the officers into the room?
I would say I don't know that there was a medical reason for them to be in the room, but
is there any police reason? Is she a threat? Is she getting up and running away? Is she doing any of those things? Is there a suspicion she has a weapon? Or is there any police reason for them being in the room?
And to try to answer your question, Justice Beal, I appreciate it. I've watched the video about 10 times. My memory of the video is I don't remember the doctor saying, "Do you want to be a part of the conversation?" I remember her saying something like, "Does one of you want to go in there with me?"
So the police should have never gone to a room? The police should have never gone to a room? Is that what they're saying? Even though, but Rosalinda, you work in medical, right? You just said in the chat. Shout out to all my beautiful, wonderful medical people. Shout out to y'all. Okay. The police should have never been invited to the room? Is that what he's saying? Oh my God. They should have just let them investigate, told them where this baby was at, and that was it. I know. Look at Carrie. Carrie's like, to hell with HIPAA, man. A child. I feel you, man. I feel you. But the medical people are mandated reporters too, right? I am so confusional sometimes. Okay, hold up.
But assume for purposes of this that that's what happened.
The answer, I do believe they had a legal reason to be in there. They were conducting an investigation.
Investigation of her medical condition?
Well, investigation of what led to the baby being put in the trash.
No, she says,
But if they're investigating,
she
you
says,
got Miranda.
Well, Miranda requires custody and interrogation, which I'll get to in a minute. But my point is that there's no legal bar to the police going in the emergency in the exam room. Now, granted, I admit it. Had the doctor said, "Look, I need to talk to her. I don't want you in there yet. Can you hold on while I talk to her?" I think the police, you can tell from the video, they were very deferential to the doctor. One thing I wanted to point out, because I believe now is a really good time to say that. There's a lot in the answer brief that suggests that the police presence there caused a delay or hindered treatment of some kind, or even delayed possibly her being flown to Roswell. I want to be very clear. There is absolutely zero evidence in the record that would support any fact finder in finding that any medical procedure or care was hindered or delayed, or that they even had anything to do with the helicopter arriving. So what I would say is, the best answer I have is I don't believe there was a medical reason for the police to be in there, but clearly the doctor did not say, "I want to talk to her in private. I don't want you in there yet. I know we called the police, we called you, but please don't go in there yet. I need to talk to her." Do they have a legal reason to be in there? Yes. Now, might it have been
what's the legal reason?
Well, they're investigating this, and they probably want to, at some point.
Watching her get a pelvic exam, is that investigation?
Well, later on in the video, when there is a point in the video when the nurse says, will you two please step out? And the police do. They step out of the hallway because there was probably medical.
Was that hindering their investigation? Asking them to leave?
No, it wasn't hindering at all. And the police were very polite. They went out in the hallway. Another thing I wanted to mention too, and again, I think some of this is more clear when you sort of watch the video from beginning to end. There's a point in the video, exactly, pretty much.
I don't know if it's just me, but doesn't he sound like very shaky in his voice? So he's like watching her get a pelvic exam is part of the investigation. Is that what the judge said? Oh man, this is a tough crowd, you guys. Honestly.
It's exactly at 3 o'clock, where you see the police are out in the hallway, and they say to the nurse, they say, "Well, we don't really want to go in there and cause her more stress. She's dealing with a lot." And at that point, it's 3 o'clock, you see the sergeant and the other officer go back into the room when they've clearly been out in the hallway. And the sergeant says, "Look, we're going to continue waiting out in the hallway. We don't want to add to your stress. We know this is stressful." And the sergeant even explains, "We can't have your mom in here right now. We're waiting for the detective. You are 19 years old, but we're going to keep waiting in the hallway. We don't want to add to your stress."
Why didn't the medical staff say that to her? See, this is where the medical staff effed up. Why didn't the medical staff excuse the mom? She's 19. Like, I was so confused when that happened. I would agree with that. Listen, you about to pop off. You gonna go off on the judge? I'm confused. Like, I don't know. Anyways, let's keep watching this.
I know at answer brief page 9, it certainly seemed to be making the claim that the police were in their room the entire time for that 2 hours or 2.5 hours, and that's just not true. From 3 o'clock until she was taken away by the helicopter at 4:30. Pretty much 99% of that time, from 3 a.m. to 4:30, they were waiting out in the hallway. And I don't know if I answered your question, but
but that was after the incriminating statements were made that were suppressed.
Well, yes, but the one thing I hadn't got a chance to get to yet was that it's 3 minutes. It's 3 minutes into the lapel video that they tell her, "You're detained. You're not under arrest, but you are being detained." Put aside, of course, the cases that talk about being detained.
She was detained, not arrested. Okay? She was detained, not arrested.
Is different than being in custody for Miranda. Even if it.
Oh, so detained is different than being in custody for Miranda. Y'all peep that. Somebody write a note about this.
Even if this court believed that she was in custody at that point, 3 minutes into the lapel video, and everything else was suppressed, she had already made the statements. And that's why I mentioned in the brief in chief that the motion was a little bit broad, and not the other side's motion was a little broad in not limiting the request to exclude statements to at least the point where she was told, "You're not under arrest, but you are detained and you're not free to leave." But it was a little bit overbroad. And the case here, I'm trying to find the case.
Roden says that detained is not custody. So if you're detained, you're able to, but the girl just had a child and she needs to have her placenta removed. No, excuse me. Her placenta. Why am I getting this off? We don't know what happened to this placenta, okay? But she was bleeding nonstop, so she needed a DNC, Okay, y'all know what put it one in the chat if you know what a DNC is, because I don't want to get into that. But she was bleeding profusely, so I don't think all her placenta was out, but there were pieces that needed to be removed. Okay, so things needed to be done. So she had to be hospitalized afterward, or at least go get a procedure. Y'all know what a DNC is? Okay, cool. I don't have to explain that. Put a 2 in the chat if you don't know what it is.
Yes, State v. Philemon v. 2018 NMSC 11 talks about the difference between investigative detention and a custodial one, is that the latter, meaning custody, involves coercive conditions as to constitute the functional equivalent of an arrest. The one thing I also wanted to notice, and I know I'm not trying to get away from the interrogation, I'll be glad to answer any other questions on that. But of course, we know that there has to be both interrogation and custody. Putting aside the agency issue, Santiago case, whether the doctor acted as an agent of the police, there's clearly no custody here. And the cases that support that are 3 cases, one in New Mexico and 2 others. State v. La Couture, 2009, NMCA 71. And that's the case that was provided in the notice of supplemental authority back in March. And La Couture, some of the things they say in that case are almost 100% applicable here.
So he's quoting cases now. For those that don't know what a DNC is, it's basically where they widen the cervix, they dilate the cervix, and they basically open it up to then clean it. Okay, so clean like any tissue, anything like that, especially like in the lining. And so there's a surgical instrument that's done. I've had this done before when I had a miscarriage, and it's supposed to help, if you're bleeding profusely, this is supposed to be a thing that you're supposed to do because it does kind of help clear that cervix. So yeah, it's a procedure that has to be done when you can't stop bleeding, if that makes sense. That, and also sometimes this procedure is done in other ways as well. Okay, let me hit play on this, okay?
Couture said was, La Couture, and he had been involved in like a DUI or some kind of accident. He was in the hospital for injuries. And what the court said was, the fact that La Couture, this is paragraph 18 of La Couture. The fact that La Couture was restrained by injuries and medical accoutrements warrants little consideration. This is a Judge Kennedy Court of Appeals opinion. La Couture was exposed only to circumstantial restraints, and as stated above, the record indicates no action by Officer Diaz to restrain him. And La Couture, just to be clear, is not an outlier whatsoever. In the reply brief, I cited State v. Garrison, a July 2024.
So he's just citing cases because they have to cite cases for research. You know what, neuropsych, you're right. He's talking on overdrive. He's like on it, and I don't know if his mic is going in and out. And I was speeding it up. I'm not speeding it up now. He's talking fast. That's why the judges had to tell him to calm down a little bit.
Or Connecticut Supreme Court case. And
so is it your argument today that the custody was circumstantial custody? Because it's not like, she's just delivered a baby, is bleeding out. It's not as though she's going to flee at that point. So are you asserting that there was no custody at all, or is it circumstantial custody from your perspective?
Well, custody, of course, can be formal arrest, or as the cases talk about, a restraint on liberty that basically, what's this, how they phrase it?
Yeah.
Yes.
For those that don't, it's not. DNCs are not just for abortions. I had to have one, and it was through a miscarriage. It's a thing. They use this procedure to clean out the cervix and uterus and all this stuff. And it's something that it's a safety measure too. So very much a necessary process and procedure. You said, how does she know that? I don't know. That's a great question. Sylvia's on a 5-hour energy drink. Shout out to Sylvia. You said, I think he's moving on and off from the mic, right? It's just a little bit crazy. Thank you. Appreciate it. Thank you, Ocean, for explaining that. All right, let me hit play on this, okay? He's a little nervous. You could tell. You only get like an hour. I thought this was going to be a long ass hearing. It was only for like an hour, y'all.
When the person's freedom of movement has been restrained to a degree associated with a formal arrest.
So that was a follow-up question just Bacon I had, which is, so is the restraint of movement of the defendant based on the condition or that there were officers in the room? Does it matter?
Yes, I don't believe it does matter because on Garrison and there's also this Johnson case that I cited in the notice of supplemental authority 2 weeks ago, talk about the fact that if you're in a hospital, yes, officers may be present, but if the officers are not doing anything additional to limit your freedom of movement and they're being polite, they're not being antagonistic, that alone is not enough for custody. And in Garrison, it talks about an example in Garrison at page 289, it's 323 8th 289. The court says, because there is nothing in the record to suggest that any of the officers with whom the defendant interacted were threatening or aggressive, we conclude that the tone and tenor of the questioning weigh against the conclusion that the defendant was restrained. And I can't find it off the top of my head. The court talks in there about the fact that the real key is whether the police did anything to further restrain the movement. And probably the case that really best addresses that is the Johnson v. Commonwealth of Virginia. This is again.
Oh man, they're pulling out cases. He's pulling out cases. I love how much he's sweating. I can see it in the back of his neck. Y'all see that? I can zoom in if you want, but he's got some sweat right there. Hold up.
2 weeks ago,
The sweat's right there, y'all. Okay, let me keep playing.
Supplemental authority 916 Southeast 2nd 910, and what the court says in that case at page 921. So this is 916 Southeast 2nd at 921. The court says the medical equipment connected to Johnson would have made it difficult for him to get out of bed, but his immobility was not caused by the police. Johnson was receiving essential medical care because he had shot himself in the chest.
I follow all of that, but here the police didn't leave. They stood outside the door. They said, we're standing outside the door. They shut the door. Isn't that some evidence of restraint or custody where they didn't have to, handcuff her because
they were okay, let's be very honest. They were outside. I watched that body cam footage from the officers. One officer was standing and he was talking to the person about, hey, how about that coffee? Let me get some coffee. Let me know. Didi, are you going to bed? Shout out to Didi. I'm just saying, he was, I saw that body cam footage and they were having water cooler conversation and stuff. So yeah, I mean, why would an officer stand outside of your door unless you're not detained or detained? I don't know. Y'all let me know what you guys think in the comments.
because she's medically unstable. But isn't the fact of their presence and standing outside the door to prevent somebody from coming and going, and they're monitoring exactly where she's going, they know she's going to be transported, all of that, isn't that some indicia of further restraint based on the language you just read to me?
I don't believe that would meet the test of state being that was cited in the brief, which is the degree associated with a formal arrest. Because again, when you look at Locketeur, Johnson, and Garrison, they really are saying that yes, you may have an IV line, maybe you're injured, you may not practically be able to leave the hospital, but the police aren't doing anything to further restrain you. So I don't believe them waiting out in the hallway would be custody, but certainly any such finding would have to be limited at least to the point about 3 minutes into the lapel video when they say you are being detained, you're not under arrest, but you're detained, you're not free to leave. But unfortunately, the trial court's ruling suppressed even the statements she made earlier when the police literally were just standing there not saying a word and the doctor was talking to her. I know that gets into the agency issue.
Well, it also gets into the privilege issue, and your time is limited here. Setting aside Fourth Amendment for purposes of our conversation and the privilege, it appears that the state is taking a position that everything that the victim said is admissible because of the doctor's requirement under statute to report that as a crime. And I'm struggling with that. I can see the doctor, as she did, say we have a deceased individual and I need to report that.
There was a doctor, remember the lady with the white coat, she was in the room and she was the one confronting Alexi. She was confronting Alexi and confronting the mom, or at least letting the mom know what happened, okay? Yes, and Kim says the argument could be made that they stayed outside the door because if something happened to her in that room that caused her great harm, cuts both ways. Yeah, maybe she might have escaped, or I don't know. I mean, she was 19, you know what I mean? She was 19.
But the rest of, it seems at that point, you're just opening it up and all the privileges are just waived and whatever that defendant talked about is admissible. Can you address the privilege issue?
Yes, I'll do it very quickly and I'll be glad to do it more in rebuttal. Two things, 11504D4 does have the exception, and as I noted in the brief, this court clearly has, as the issuer of that rule has, and I mentioned this in the brief, has a common law ability to interpret that rule. I would say 11504D4 certainly covers this, but the other big issue is the waiver, the fact that she spoke to the doctor with the police present and her mom present.
Okay, so mom's there to take care of her?
Well, she was 19 years old though.
Okay. And the officers, to Justice Bacon's question, and you can address this, I'll give you some time. They were at least guarding, at least if we're not going into the Fourth Amendment, they were in there. So that's a struggle with that waiver.
And she's on a myriad of drugs.
I understand. So real quick, the only thing I would say, Your Honor, if you allow me 10 seconds, is that
It's okay, it's okay.
is
She's in myriad of drugs. Okay.
that imagine it's the situation.
That just tells you the judge, the lady over here, the one between, I can't even describe them because they're all wearing black robes, but the judge lady over there, kind of giving Judge Judy vibes. She already made up her opinion in her mind about this situation. She just said it. Okay.
Situation had been the doctor had gone in before the police got there. Let's say the police were on their way and the doctor goes in and says, well, I'm sorry to tell you, but we discovered a dead baby in the bathroom. And then she says, I'm sorry, it came out of me. I didn't know what to do. I think that would not have been privileged. And let's say the police arrive 3 minutes later, because that goes to the heart of the D4, 11504 D4 exception. So I think one way to look at it is, had she made that statement in response to the doctor's statement, we found a dead baby in the bathroom, even had the police not been there, I believe that would have not been privileged under the spirit of State v. Strouts and 11504 D4. And I'll sit down and wait.
No, don't.
Take your time.
Justice Moore has a question. Justice Moore, did you?
It was more clarifying. You talked about the mom being present during the conversation and the statements made by defendant. And yes, the defendant was 19, but I might be remembering wrong. It's entirely possible. I want to see if I am. Wasn't there something she signed authorizing her mom as a caretaker or a party that she wanted?
Contact?
Maybe something where she wanted her to be present during the medical treatment. And does that do anything?
Did she sign that? Do we know that? She signed something that said that she wanted Mama Lexi. I told you about this. She wanted Mama there.
With the waiver issue? If my question makes sense.
I don't know if I can answer that off the top of my head without going back and looking at the record, but I believe that the general rule is that the presence of a third party not strictly necessary, like a paralegal being there during an attorney-client conversation causes it to be waived. Thank you for the answer.
Thank you, Mr. All right. 30 minutes for appellee. May enter your parents and proceed.
Thank you, Chief Justice. My name is Amber Fairberg on behalf of the defendant, Ali. Good morning.
The defense is here. Have a good night, Smiley. Thank you for stopping by. You said that judge is totally in favor of the Merc Mama. It's crazy. Lexi's just evil by calling the baby it. It wasn't breathing or nothing. That's what she said. That's what she said. Okay, let's keep going.
Chief Justice, justices of the court, counsel. As I said, my name is Amber Fairberg. I represent Alexi Trevizo, the defendant appellee. The legal issues here, although that conversation got somewhat convoluted, are actually relatively straightforward. It's the ramifications of this case that are extraordinary for Ms. Trevizo and for every vulnerable patient in New Mexico, and for the state's commitment to safe, confidential reproductive health care. And even more importantly, to maintaining the line that separates medical care from police investigations. Physicians and medical personnel take on the role of caregiver. Police take on the role of investigator. If we accept the state's position in this case, that line completely disappears. And it's to the
what do y'all think? What do y'all think? That's the defense. What do y'all think?
Detriment of New Mexico patients at their most vulnerable moment. Police are in the emergency department every single day. This is something real live doctors have to navigate every single day. And the people who are there are inherently at their most vulnerable moment. There are guidelines here. The state's position is essentially there is no limit. If there is a reason to report, and I want to get into later which reporting statute is actually applicable here. I would argue it's a suspicious death and not child abuse. Those are two separate reporting statutes. But the state is arguing if there's a duty to report, there is no privilege, there is no Miranda rights, there are no more rights. We just go on in this joint investigation.
I'm not sure that I agree that that's where the state's gone. You're blending the two. I think Miranda.
Yes. Go ahead, Judge Judy. Go ahead.
The argument, as I understand it from the state, isn't related to the duty to report. I think the duty to report becomes important in the privilege conversation that I really do want to explore with you today. But Miranda just seems to be, they were invited into the room and they didn't do anything. They were polite, they were nice. I heard that a lot. And therefore, there was no detention, no interrogation.
Yeah, thank you for the question, Justice Bacon. And you're right. You're absolutely right. There is the mandatory reporting falls under the privilege issue, where I think the state is largely mistaken. But let's talk about Miranda for a minute. Let's talk about that custody, because all of the cases that we just heard counsel cite are completely distinguishable here.
So when the state agrees that there was no medical reason for having the police officers in the room, does that bear on Miranda?
Absolutely.
Tell me how.
Absolutely. Well, to answer your question, Justice Vigil, there are basically two universes we can be in. We can be in an investigatory universe where Miranda applies, or we can be in, we're here to support the doctor, and we're in the medical universe and privilege applies.
Well, and that's the question. Ma'am, there's no privilege when a crime has been committed and it's being investigated. Whew, let's talk about it. What do y'all think? Y'all are heated in this chat. Are y'all okay? I just wanted to do a live reaction with you guys because I know we played this earlier, but I hadn't watched this whole thing.
The state can't thread the needle through those two by admitting that there is no medical purpose for the police to be in the room. That's effectively an admission that they're there to investigate a potential crime.
But is investigation the same as interrogation and detention?
That question doesn't go to custody. I am interested in that. I mean, does the answer to Senior Justice's question mean they're in custody? Because then you get to interrogation.
Well, I want to make sure I understand your questions. So I want to make sure I understand your questions appropriately before I answer. There is a difference between investigation and custody, but in this case, there wasn't. In this case, there wasn't, and the reason is because of that pre-confrontation conversation that occurred in the hallway that the justices were discussing earlier, and that's that conversation where police are told by the charge nurse that she entered the bathroom to, and again, the charge nurse never treated Alexi.
That really seems related to interrogation. We're talking about custody. The question is, was she restrained? Was she free to leave? Those are the kinds of things we're looking at when we're deciding whether she's in custody. And what I'd really like to hear your take on the two cases where custody is an issue in New Mexico, and we're dealing with medical care emergency rooms, and that's Ibarra and La Couture. Ibarra, we have a defendant who is clearly in custody. He's been arrested already, and he's taken for medical treatment in the emergency room. And then we have La Couture, where they're not in custody yet. Tell me how those cases bear on this situation.
Absolutely. Ibarra.
So again, they're making arguments. And Cheeks, I agree with you. Reproductive autonomy is one of the most important causes to me, but that does not include confidentiality after you throw a baby in the trash and then we find out that the baby was breathing. Like this hits at the core of a lot of things, y'all. Honestly, it really does. Thank you. Just me says I'm new to your chat. Hi, Rabbit, and everyone. In my opinion, I won't be surprised. I hear a lot of people get away with a lot of when it comes to things like this and other crimes. Shout out to you, Just Me. Thank you for coming out of the bushes. She was, you said, free to leave, but not because she had a medical emergency. So which one is it? That's the question. Let's see what they say. He says, I think I'm confused. The state argued that the cops shouldn't have been in the room. Am I, hold up. You said, am I getting the lawyers backwards? They went back and forth on that. on the conversation about her being detained, why was a cop outside the room? Which all of that did happen. We did see that body cam footage, which, by the way, it's available on my channel if you need a refresher. Okay.
Says and I don't have the pin site on me, but Ibarra says, I do have it. Ibarra uses the term an inherently coercive environment to describe the emergency department. And that's directly contrary to what the Court of Appeals said in La Couture, which effectively said this is just a normal situation, but that was factually distinguishable.
But Ibarra was already in custody. There was
Correct.
no question about custody in Ibarra.
Correct. Your Honor is absolutely right. The reason it matters, though, is because that inherent coercion also goes to custody under Munoz. Munoz gives us, the conversation earlier with counsel got really focused on custody only being a restriction of freedom to the degree normally associated with formal arrests. But in New Mexico, it's disjunctive. We have two ways that somebody can be in custody. There's that way, which normally comes with handcuffs and everything else. And then there's the second, which is that a reasonable person in the same situation, and in this moment, let's put ourselves in the mind of a reasonable 19-year-old high schooler, would not feel free to leave. And that's where Ibarra, I think, is so important, Your Honor.
Listen, I'm with you on this one right here, but in my opinion, it changes everything. Listen. Did she know she was pregnant? Family knew she was pregnant. What were her Google searches? They're stuck on this piece because this is where the evidence is coming from, right? That body cam footage is very damning, and it's something that the prosecution wants to use, but it's very damning. If they can't use it, it sucks, but it's damning to Alexee's case. This is why they're arguing that. If that body cam footage goes out, what else do they have? What about Google searches? Am I pregnant? Could I be pregnant? How to get rid of a pregnancy? Okay. Let's hit play.
Because it talks about the inherently coercive environment of the emergency department and cautioned police against exploiting it.
I ask you just
Yeah.
in answering that, can you, because the state did, can you, in discussing custody, talk about the 3 minutes prior to the officer telling her that she was detained versus what happened after? Because the state seems to be breaking it up like that. And you might not agree. I'm just wondering if you can address that. Because in my mind, that could possibly be an issue. The 3 minutes prior to them telling her she was detained.
Correct. Yeah. So the questioning started 3 minutes prior to them confirming that she was detained. To my mind, Your Honor, the reason that doesn't bear on this case in the way that the state wants it to is because that was a confirmation sheet. And he said earlier, we heard counsel say, this isn't a whodunit. This isn't who had the baby in the bathroom. So there's nothing that was stated there that would have taken police from a place. And that's where that pre-confrontation comes in with the nurse, where he says, she went in there to harm her pregnancy. She's lied the whole time she's here. She's gonna lie to you, and she killed the kid. So they're operating under, we're in a homicide investigation now. She's our only suspect.
And
She killed the kid? Is that what she just said? This is her defense, by the way. This is her defense. I hear you, Nero. It's impossible for me to get past that garbage can. I just can't. That's that. And you know, and what's funny is, it's not funny. It's actually a really sad situation where it's like a lot of my medical folks here in the chat kind of go back and forth on this one. Like, they could see where the hospital might have failed, or even law enforcement, but they can't get past the fact that, like, she still put that baby in the trash, put a liner, tied it up, put a liner, and this baby suffocated. So I don't know, man. She had morphine, she had all kinds of medication. This is what they said. Okay, I don't know what the medication reports looks like, but y'all let me know what you think in the comments.
I think the through line of what you're saying is Miranda doesn't require confirmation by the police that you're being detained. I mean, our case law all over the place handles cases where there is no confirmation.
Absolutely. And the one thing that we haven't yet addressed, Justice Bacon, is the main difference between those cases on which the state relies and this one is the placement of police, where they're either just in the emergency department, they happen to overhear, or they're standing back, and there's this independent conversation. What we have not seen in any of those cases that makes this one markedly different is that these officers were physically blocking the door. We heard counsel talk a lot about that video. In that video, we see Alexi Trevizo on the bed, hemorrhaging in a hospital gown. Those are the circumstantial ideas, right, that we talked about earlier, that your honors talked about earlier, in terms of circumstantial custody, that she's not free to leave. But that's not what puts her in custody for Miranda purposes. I mean, that's part of the coercive environment that they're.
I don't think so. And that's a good question. Did she attempt to leave? Are law enforcement there investigating the death of a child in the bathroom, or are they attempting to apprehend her when she's not even leaving? Like, we don't even know. And like I said, this thing is like a mess all over, because you could look at various angles to this.
They're exploiting, that they're taking advantage of here. But the reason she's in custody is because she has 4 authority figures acting in concert, only one of whom she's ever seen before. That's the doctor, the charge nurse. And as if you've all seen the video, he's a large man who aligned himself very strongly with police. These 3 men walk into the room.
Well, that charge nurse, I saw the interrogation video and I saw him. He looked traumatized. I remember him saying, we were right there. We could have saved this baby. She didn't give us a chance to save this baby. So yeah, I get it. I get his frustration.
And they're physically blocking the door. The operative question for the court is, would a reasonable 19-year-old high school girl in that situation feel free to leave? And the answer is no, even if she wasn't hemorrhaging, even if she wasn't hooked up to an IV, even if she hadn't just experienced the first vaginal exam of her entire life and the precipitous labor and delivery of what the defense posits was a stillborn in the bathroom.
How is she on birth control and she's never experienced a vaginal exam? That was the first vaginal exam and she's on birth control? She was on birth control, y'all. Please know. For the record, she was on birth control. Now, I get it. People don't always take birth control, because they're having sex. Sometimes it controls your periods, your face, your, the skin stuff. Everybody uses birth control for various reasons. But typically, that I remember, when you're having birth control, they might do a vaginal exam or at least check on you. You're 19. Y'all let me know. I could be off, but put it in the chat. Have you guys ever gone to get birth control without a vaginal exam? Yes, you've gone. Okay, say more.
Those all contextualize it. Yes, Your Honor.
I don't mean to interrupt you, but I really do want to talk about the privilege. We have not had an opportunity with the state to really talk about the privilege either, but I need you to identify something pretty specific to me, because I don't know the answer to the question.
She was sexually active, so maybe the birth control was to regular periods. But you're right, Apple Pie, maybe things have changed. I don't know. I just assumed. That's what I'm saying. You said I always had a PAP with the birth control. Listen, you said my 12-year-old on birth control, no exam. See? Things are different then, because I just assumed that you can order birth control online. There you go. You said, yeah, you can get birth control online. That's what people are saying. Okay. I just assumed that people would get it, but clearly things are different. Okay.
Absolutely.
What, to your client's mind, did the doctor say? What's the actual violation of the privilege? What are the words spoken by the doctor that you assert are a violation of the privilege?
I'm not sure that that's the way, Your Honor, that I conceptualize the privilege. The privilege is a rule created by this court as a rule of evidence. So the question is, so the doctor can invoke Alexee's privilege for her, and should have, but did not. And should have a pursuant to medical ethics and her professional guidelines, and did not. But in terms of waiving the privilege, only Alexee can do that. And so this is a
Before we waive, get to, it's a privilege.
Yeah, I mean, why is this? What is the privilege being asserted here? I mean, I know that it's a physician patient, but what is happening? What have you identified as triggering the violation of the privilege?
Well, the violation, there's actually 2 different
Okay,
violations.
and that's what I want to try and
Yeah,
understand.
there's, and you can see this from the court order, because we've got.
So they're talking about violation of privilege. And somebody made a comment earlier. Let me see. I think this is a good point. Not a gamer girl, thank you, says they don't do vaginal exams under 18 anymore. My daughter had heavy cycles and they never check her. Wow. So they must be that must be since C19, because that was a big no-no back in the day. Women are high risk for blood clots. But I mean, I always felt like access to I think access is very important, but I always felt like, I guess it's readily available now. So things have changed, y'all. Things have changed. So and that's my ignorance in this topic.
The district court made an order, one on the statements made directly responsive to the collective confrontation in the room, and also.
But that's what I want to try and get to, because if the privilege you're asserting that's been broken is the statement of, we found a baby in the trash, that's not a privileged statement, because it's not about Ms. Trevizo's healthcare. It's just a statement.
I'm not sure I would agree with you. Honor.
Well, let me
Okay,
finish. So to me, that is not a violation of privilege. The remainder, you know, we need to transport, bleeding out all of that information, I might agree with you as a violation of the privilege, but in this context, given the suppression here, I don't think anybody cares, because that comes after the inculpatory statements by Ms. Trevizo. And so if that's a violation of the privilege, sure, but it's not what is really at issue here.
What's really at issue here, Your Honor, are Alexi Trevizo's statements. It's not the doctor making a statement. The doctor and the nurse both did violate their duty of confidentiality several times by telling officers. I think you said earlier, Justice Bacon, I'm not sure they should have. But to get to the actual statement that is, there's two realms, but the one that is responsive is Alexi's statement. Alexi's statement, which was made for the purposes of treatment and diagnosis. That's the standard under Rule 504. And the reason here that it is, the doctor comes in and says, I'm sorry, there's police here. We found a dead baby in the bathroom. So this is the first time the doctor has spoken to Alexi, and she made it clear later in an interview, and her actions made it clear at the time. And this is the substantial evidence that the district court relied on, that she wasn't going to get treatment without police present. So this information, the doctor didn't know where the placenta was. Indeed, the placenta was never found. The doctor didn't know anything about the circumstances of
The placenta was never found. I don't feel like the police, I don't feel like the doctor said, you're not going to get treatment if you don't X, Y, and Z. I have to go back and watch that video again. I don't feel like that's what the doctor said. I'm just saying, but y'all let me know what you think in the comments. Maybe I'm remembering wrong.
Of the birth. So Alexi's statement confirming that birth is absolutely necessary for her ongoing diagnosis and treatment. The problem here is not, I think where we're a little bit stuck is we're imagining that the police could have come in and maybe the doctor could have said something different that wouldn't have triggered the physician-patient privilege. And I would say, no, the police should absolutely not have been in the patient care room, nor should Dr. Vasquez have instructed her entire ED staff not to interact with Ms. Trevizo except for in the presence of law enforcement. She effectively conditioned her ongoing treatment on their presence.
So why talk to me then about waiver?
Okay, let's talk about waiver.
Yeah.
So here the state is effectively saying, and this is how I understand it, that Alexi has waived her privilege by the presence of third parties. Well, all we need to do is look at the text of the rule. The rule, and instead of me paraphrasing it, I'll just read it because I think that would be probably better. The rule defines confidential communications, and then we can get to the exception, which is the mandatory reporting exception. But the rule defines confidential communication as a communication made privately, not intended for further disclosure, and then this is the operative language, except to other persons in furtherance of the purpose of the communication. Now that has a little bit of a loop-de-loop feel, because what does it mean in furtherance of the purpose of the communication? We know that from the first part of the rule, which says that the communications that are privileged are those in furtherance of diagnosis and treatment. We also have direct case law on point that says, we look at State versus Roper, and granted, Roper was construing an earlier version of this rule, that specifically said family members were exempted from the privilege, from waiver. But the current version of the rule actually broadens it. And it broadens it so that it reflects the reality of New Mexico, which is that no person is going to the emergency department by themselves. Every person has a support person, whether it's extended family, whether it's their mother. I mean, and this idea that she's 19 and therefore.
Okay, that's cute. Sometimes it's not always the case. Sometimes people go to the hospital on their own. Sometimes, okay.
It doesn't matter. That's not reflected in the law. The law says that any person, it's not someone who's absolutely necessary for care. It's someone who's there in furtherance of that care.
But so the officers are in the room and
Officer,
they are not in furtherance of her care.
I would argue, Your Honor.
Would that be a waiver? I mean, I think the state asserts that that's a waiver, like that she's cognizant of what's happening and makes a knowing decision. I don't care that they're here. I'm going to answer this question. It's not a question, this statement for purposes of furtherance of my care.
Right. I think in that idea, it kind of loops back on there's two things here. One, it loops back on the idea of Miranda, that a statement, any waiver needs to be voluntary. And so for the same reasons we would argue she didn't voluntarily waive any rights under Miranda, she didn't voluntarily waive any rights.
So, Ms. Faber, assuming for purposes of discussion, assuming that the statement by the doctor, we found a dead baby in the bathroom, was a violation of the physician-patient privilege in the context of everything that's going on, she never had a chance to waive.
Correct.
There's no waiver.
Right.
Oh,
you can't waive a right that.
Oh, y'all hear what I don't know what's sorry, y'all, forgive me. I don't know the justices' names, but the guy in the middle, okay, or at least going down this way, what did he say? That's interesting, right? She never waived a right.
You've not been informed.
And she had no, and by the way, a fact I think that you left out, and I don't think you meant to, on the custody, is that the officers were armed.
Absolutely.
Visibly armed.
Absolutely, visibly armed. And if I could just add one more thing to speak to that, Justice Vigil, and also finish answering your question, Justice Fagan, they also fit into other persons because the reason is because of what the doctor said. That and the charge nurse verified it and said the exact same thing. No one's talking to Alexi, aka no one's treating her except in the presence of police. So in that situation, they're absolutely in furtherance of care because she's not.
But how is the mom in furtherance of the care? She's actually she was questioning her daughter more than the police were, and it wasn't about her.
And the staff. Lexi, what'd you do here, Lexi? I told you about this, y'all. She really was, y'all. Yeah.
Treatment. It was about you did this and you're going to be in trouble and all of those comments. And in fact,
I told you about this, Lexi. Remember? I was like, oh, she said this in front of the officers there. What did you do with it? She even asked Lexi. I'm sorry, because I'm like, damn, the mama did no justice here. She even looked, oh my God, what did you do with it? She went crazy on her. Yeah. She did. Y'all saw that. Sister Crab's like, yes, Rabbit. You're right, Rabbit. You're right. Oh my God, Franny Law's in the chat. Shout out to my Franny Law. Anyways, you said mom was team too much. Detroit. Yo, she did. She was like, damn, you don't even need the police here. Your mama just interrogated you, girl. That's crazy.
Remember correctly, I think the police even at one point said, please stop. So how was the mom there in furtherance of her care?
I think we have to step back and look at the totality of the circumstances for that. The statements that you're pointing to, Justice Zamora, or from mom are her own reactive statements to what she's just learned. But in the course of Alexi's care, she brought her there as her emergency contact. She was asked by medical professionals at one point to help her get into her gown. She's been going back and forth to the bathroom to knock and see if she's okay. She's sitting by her daughter's side. She's advocating her. That's absolutely in furtherance of care. Just because we now in retrospect think, oh, some of her statements might have been against Alexi's interests. That does not mean that in the moment she was not there in furtherance of care and that the physician-patient privilege does not attach.
So we have exceptions to that.
Correct.
Let's talk about those.
Let's talk about D4.
Let's talk about a statute that also exempts it, a statute by the legislature. We have, interestingly enough, this privilege exists in statute seems.
Vic, she's suing the hospital. She's suing the hospital currently. So I don't even think she's waiting for the outcome of the. I think they're wanting to use the hospital lawsuit with the criminal trial. Somehow that's going to help out. So yeah.
Their rule was generated out of common law 32A45, and then let's talk about those two things because it seems to be a high burden on this doctor who has an obligation to report a crime. I think perhaps lawyers have that obligation. You know, take a separate factual scenario in which they ask a 25-year-old, you know, stabbed in the leg, I killed somebody. They having that conversation as a doctor and a patient, I'm not sure it means the exception doesn't apply. Why doesn't the exception apply?
So you're saying, why doesn't the mandatory reporting exception apply to the statements that are happening after the collective enters the room?
Or under the statute shall not be excluded on the grounds that the matters be subject of a physician-patient privilege or of their similar privilege under 32A or 5.
Right. So I think there's a couple of things here, and one of them is that the report was already made to the extent that it was applicable. And I just want to step back for a moment because we've got two operating statutes. The state has focused exclusively on 32A43, but there is also, for your honors, 2411.5, and that's reporting a suspicious death. 32A43, excuse me, is part of the Children's Code. And we know from Strouch.
The Children's Code, that's federal. Okay. So this is that mandated reporter stuff, guys.
And its legislative history, that the purpose of that statute is to intervene and protect a child from ongoing abuse. And so hence the mandatory reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen, including you have to report it either to police or to CYFD. If it goes to police, police need to report it to CYFD. CYFD then gets involved. That's not what's happening here. There's nothing in discovery. There's nothing in the record that police ever got CYFD involved because this isn't the operable statute. The operable statute is instead 2411.5, which is reporting a suspicious death. There is no dispute here that doctors did not try to resuscitate this neonate, that they found the neonate cold, blue.
The baby was gone. The doctor, I remember the interrogation, the female doctor was like, there was no life-saving measure anymore because the baby was already gone. And so then they're saying, well, the police never called CPS because the Children's Code say that, so there is no child abuse or neglect. It's suspected child abuse or neglect. But the child's already gone, deceased. So what did you want CPS to do? Huh? I mean, you could call and report that the child has died, but like, there's no child. That's crazy, yo. She really done twist that. Okay. Sorry, y'all. This is the first time I'm hearing this.
Very clearly deceased.
I don't disagree with that recitation, but there also is an OMI report, at least according to the briefing. Is this a question of fact?
I think that part probably is a question of fact, but what's not a question of fact, yes, the stillbirth versus live birth is absolutely a question of fact. But the issue of what people knew at the time, as far as a report, there was no OMI report at that time.
It does triggering the suspicious death statute.
Correct. All they saw was a suspicious death. And so that requires one of two things, either a report to local law enforcement or OMI. And then it's up to those people to take on the investigation. But even if we are operating in the realm of 32, of the Children's Code 32.
Hold up. I am so confused, but okay.
32A43 and 32A45, I would still argue, Your Honor, that any reporting is not prospective reporting. It's not an ongoing duty of some sort of ongoing duty of disclosure. That would de facto turn a doctor and any other mandatory reporter into an investigator by police.
The only thing the doctor was required to report was, we found a dead baby.
I would say that
that's correct. Okay, we found a deceased baby, but what is CPS? How does I guess my thing is that they're trying to argue that the mandated reporter law is one thing, right? But if there is no, if the baby died, what? How does the? Okay, I guess I know where she's going with this, but let me hit play on this.
the doctor was required to report the basis of her reasonable suspicion for child abuse. So we found that's what the statute says. And that's what happened. We don't know that the doctor did it. We think it was and obviously the nurse was the first one to have a conversation with the police. The report was made. Now it's up to them to take on their investigatory tools. It doesn't mean they have an ongoing open entry into her medical records. The other thing that I would point out.
That's so weird. So now it's up to them to investigate. What did you want CPS to investigate? This is a crime scene. CPS has been involved. There's cases out there where children die, typically, whatever may be the circumstances, then you call law enforcement, but that's a criminal aspect of it. CPS is only investigating what's child abuse and neglect, but how do you investigate child abuse and neglect of a deceased baby already? That doesn't make any sense. You're supposed to go out there and report the baby died? What? This is crazy.
For Your Honor, especially Chief Justice, I want to make sure I'm answering your question, is that the records referred to in the Children's Code, I would argue generally referring to the records of the abused child. It doesn't mean, well, now let's look at the suspect and prospectively and in an ongoing manner have access to their records. That's why we have other investigative tools. They could have gotten a search warrant for her DNA. They could have gotten they could have taken her clothes and conducted communications on those. They could have gotten other warrants for medical records. They could have subpoenaed things. They didn't do any of that. Instead, that very night between them and the hospital.
Some of it is based, some of the duty to report child abuse is based on the mother's records, because the pregnant woman who her toxicology screen might report a basis for child abuse, her self-report or clinical observation. I think when it's a drug exposed baby. So there is some basis in the statute. We're not just looking at the child.
Correct, Justice Zamora. But what that portion of the statute also shows us is New Mexico's commitment to reproductive health care. And that what that section says is that mom's status as having used drugs.
Okay, again, if a baby is born drug exposed, yes, that's a call to CPS. They test out they may not get involved right away until that meconium comes back. They're figuring out like what it tested for and what not. Yes, that's a call to CPS of a suspected abuse or neglect. Okay, but the baby's born alive. When the baby's gone, somebody intentionally put it in the trash. That's a crime scene. That's not a CPS report. I mean, it could be, but what do you want CPS to do? The victim is deceased.
Is not an automatic showing of child abuse. So I think here, if we're reading it in total,
and there are no other children involved. Okay, it's just the one baby and the baby's deceased.
But I still would urge Your Honors. I think that the morass of 32A43 is avoided entirely by realizing what doctors saw, what they perceived, what mandatory reporters perceived was a suspicious death. We're not in the realm of CYFD. That's just not where we are here.
We're in the realm of doctor-patient privilege.
Correct.
If the defendant would have said instead, same scene, and the defendant would have said,
yes, CPS could have taken note. That's fine. CPS would have just been like, well, you need to call 911 or call law enforcement, have this investigated. Baby's deceased. They would have taken note. Of course. But there is nothing else that they could do, right? Like, they can't do anything about it. They can't. There's no child to interview, if that makes sense.
the doctor says we found a deceased individual in the trash can. And the defendant said, I killed that individual. Would that have been privileged?
Well, Your Honor, I would say under that hypothetical, no, the
Okay.
reason being that that statement would not be for the purposes of diagnosis and treatment.
Okay,
That's, yeah.
fair enough. So let's get to the statements that are suppressed and tell us how that falls. Basically, in essence, the defendant said, baby fell out of me. That, your view is tied to direct medical treatment because of the hemorrhaging. Understand that?
Not only the hemorrhaging, but what she's describing, what Alexi is describing, what we hear from hospital personnel and what we hear from the state is that from the moment Ms. Trevizo got to the hospital, that she was lying. Well, what do they base that on? That she said that she was bleeding, that she was in 10 out of 10 pain and she wasn't pregnant. It is surprisingly common how many people don't know they're pregnant until well into that case. So that's what they're basing her lying on. But what it really shows, and
Okay, so that's the case. So let's just say she didn't know she was pregnant. Did she find out she was pregnant after she gave birth in the bathroom? When did she find out she was pregnant? That makes sense. So she didn't know she was pregnant. Let's just say that that's the case. Maybe Alexi didn't know she was pregnant. Maybe she did not know. But she found out after she gave birth, right? I'm assuming you got a whole, baby coming out of you, okay? Like, you're going to find out at some point. That's not even the argument. At this point, it's like, well, when she had this baby come out of her, why did she put this baby in the trash can? And then she put the liner on the baby. It doesn't make sense.
Delivered at 10.
Not only that, Justice, but also it shows an obstetric emergency. She was probably having a placental abruption. And so what her describing to the doctor, what happened in the bathroom.
A placenta abruption. So now we don't know where this placenta's at. Now we're going to say it's an abruption. How do we know if we don't know where the placenta's at? They couldn't find it. They had a DNC on her, I'm assuming, because they were cleaning her out. They didn't find a placenta. So she gave birth to it. Did she flush the placenta? It's crazy. Okay.
Would have been extraordinarily important. It is extremely unusual for a woman to be able to go into a space and within an 18-minute period, deliver a baby, deliver a placenta, and then walk unassisted back to her room. That demonstrates the amount of morphine that she probably had in her system at that point. Because I think, just as a matter of common sense, that's not something you should really be able to do. She would have been, so the idea here is she was in the midst and continued because of the hemorrhaging in the midst of a placental abruption. The doctor did not know where the placenta was. Had any of that been retained in her uterus, she would have bled out and died. So the idea here that her job, she had nothing for medical purposes to say to the doctor is simply not the medical reality. They needed to have an open conversation to make sure she got the care that she needed.
Can I ask a really different question that's just been weighing on me? So assume the court agrees with you on either Miranda or privilege. The case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here?
I see.
And so I see, like, you all will be gone. There will be a new attorney involved, probably a public defender, and we will have excluded statements that are consistent with what her defense is. And that just troubles me in a weird way. That's why I said it's
Have a good night, neuropsych. Okay, thank you for joining us. Glad to see you tonight.
just a related but far field question.
Yeah, I think that I appreciate the question, Your Honor, and I'm not going anywhere. I'll be there for trial to the extent that it happens. But that's just not the operative question for the court to think about trial strategy and so on. I would point the court to State versus Gutierrez, in which this court has decided that they take a different approach than the feds do, for example, on constitutional rights.
Most things.
On most things, And that approach is, we vindicate her rights because they need to be vindicated. Not for deterrence, not for anything else. Her rights were violated. What we need to do here today is try to right that wrong. And then when we get to trial.
She decides to voluntarily
Correct.
use the information.
Correct.
No harm, no foul.
Correct. Exactly, Your Honor.
Thank you.
I realize that I am running with only 38 seconds left to go. And so I just want to highlight for the court, and I want to make sure I answer all of your questions, but I want to highlight for the court the policy impact for New Mexico of this decision, that it really matters. The stakes here just reach far beyond Alexi. If the state's position is adopted, the message is clear. And that's, in moments of crisis, patients can't trust what they say to medical staff will remain confidential. And that's going to chill patients, especially adolescents, especially our rural patients, especially our vulnerable patients. It will also destabilize the physician-patient relationship that forms the bedrock of our healthcare system. And the district court drew that line correctly. Miranda and Rule 504, the relevant medical ethics, mandatory reporting statutes being narrow, that's where the line lies. In this case, it was completely obliterated. So to erase those safeguards would not only reweigh the facts, we haven't talked about standard of review here, but would not only reweigh the facts, which is what the state's in court in encouraging this court to do, but it would also reshape emergency care so that vulnerable patients would be at risk. And I just want to end on one thought, Your Honors, and that's that this case isn't about whether hospitals can notify police of a suspected crime. They can, and in most cases they must. It's about what happens after. It's about what happens after that notification. Doctors are caregivers. Police are the investigators. Our law keeps those roles distinct.
That's it, man. Just don't throw the baby in the trash. Don't put a liner over the baby. That's it. She wanted to conceal it.
And it's essential for New Mexico that we continue to keep those roles distinct. And I just want to thank Your Honors for your questions and also ask that you please affirm the district court's order on both grounds, privilege and Miranda. Thank you.
Okay, one moment. Let's see if we have any other questions. Okay, thank you, counsel.
Thank you.
All right, Mr. Thomas.
Thank you.
10 minutes.
Thank
Rebuttal,
you.
10 minutes.
Yeah, I just wanted to start off, Your Honor. I will try to talk slower.
It's a lot. It's a lot. I think as you have this conversation, if you can help us separate the Fourth Amendment part and the privilege, but go ahead.
Yeah, and I did make some notes, and please jump in with questions, but I did make some notes about just a few things I wanted to really hit quick. One is that I don't think there's any issue here about whether the doctor had a duty to report, because whether you call it under 32A43, and I did realize that 32A43 talks about a neglected or abused child, but as I pointed in the brief, just from this court's common law interpretation, and it would be odd to say, well, you have a duty to report an abused or neglected child, but not a dead baby. And I'm not going to read much. I don't want to get into the details much, but the defense.
Well, you have a duty to report abuse and neglect of a child, but not a dead baby. Listen to what he just threw out there.
His own Exhibit D at the suppression hearing, the defense's own Exhibit D.
Did the defense say you don't have a duty to report a dead baby? It's a good point.
As in Delta, talks about how the Leela, the custodian lady, what caused them to call the police was that she had found a baby wrapped in a trash bag under another trash bag. Now, as sad as that is, clearly that's a suspicious death. No different than if a 30-year-old had been found in the cleaning supply room with gunshots to the head. And so I wanted to make a few other quick points. So in custody, I know there was a lot of talk about what the charge nurse said, and I maybe didn't articulate this really well earlier, but my point was that whatever was told by the charge nurse to the police would not have affected the defendant's objective, reasonable view. It's an objective view of what a reasonable person in that situation find themselves to be in custody. And none of what was said to the police in the hallway would have been known to her. It's worth just a few.
But it's not about what was known to her. It's about what was known to the police when they said, yes, sure, we will go into the room and have the conversation with you, because that's their yes to the statement. So it's not about what she knows. It's about what the police know and what their motivation was to go in the room and have a conversation with Ms. Trevizo.
And I understand that, but and certainly if the police had gone there, gone home with their guns drawn or something, saying you're not going anywhere, you know, and immediately have made it clear you're in custody.
But they don't have to say any of those things for it to be custody.
And I understand that, but certainly what the defendant is perceiving or hearing is really what is the defendant perceiving and reasonably hearing and seeing. The one thing I wanted to point out is this reference to the police being armed. I mean, it's common knowledge to anybody the police are armed. They could be safe 1 minute and 10 minutes later be dealing with a very dangerous situation. I'm not saying in any way, shape, or form the defendant.
But what about where they were standing in the room? Opposing counsel talked about their location in the room, which was in front of the door. That doesn't seem to support your position that it was not in custody.
Although I would argue that the fact that for nearly about 2.5 minutes, they said absolutely nothing. They just stood there and observed certainly bears on defendant's perception. Just a quick 1 or 2 quotes from Garrison, because Garrison really, the Connecticut case gets to the heart of this. Garrison talks about not all restrictions on a suspect's freedom of action rise to the level of custody. And then they go on to talk about whether a reasonable person would believe that there was a restraint associated with a formal arrest. But another thing that Garrison mentions, I guess this is the part I looked for earlier and I couldn't quite find earlier. Garrison says there's nothing in the record to suggest that a reasonable person in the defendant's situation would have perceived the police officers to be exercising any control or authority over the medical staff. Indeed, the record demonstrates that the officers did not assert control over the medical staff and that the questioning did not delay, interrupt, or restrict the defendant's medical care. I don't want to belabor the point, but if you do get a chance to skim Johnson, the Virginia case from the notice 2 weeks ago, Johnson gives a list of the kind of factors that might be relevant in a hospital, and one of them is whether the police maintained a constant presence in the patient's hospital room. As I noted, from about 3 a.m. to when she leaves in the helicopter at 4:30, you can tell from their camera they're out in the hallway. But one other thing I wanted to
But
mention,
they've told her.
and I understand.
We're out in the
Let's see how
hallway.
they make the statements.
And they,
Which is equivalent to being in the room to be like, we're standing out right outside the door.
Yes, but again, at the point of the
Yeah, they have a problem with the fact that PD police was standing outside that door, y'all. They have a problem with that. So I do wonder what they're going to decide on this. Okay, we got about a couple more minutes, and then we're done here.
3 minutes into the lapel video, when they tell her you are detained, you're not free to leave, you're not under arrest.
You're the one who raised they were outside the room. You want to focus on the 3 minutes, but you also want to focus on, oh, they were good guys. They left the room after the 3 minutes. Can't conflate it.
Yeah, and I understand, but my only point is that even if the court wants to consider the point where she's told she's detained to be custody, the motion should have been more specific on that, because I don't think there's anything in the first 3 minutes until she's told she's detained that would lead a reasonable person to believe they were in custody. And I would be remiss without at least mentioning this. If you look at the judge's findings at RP 159, I'm sorry, 158. The judge in her conclusion of law number 3, record proper 158, the judge says, Dr. Vasquez, by failing to advise Trevizo of her right of confidentiality, and she cites Rule 11-504, acted as an agent of law enforcement. I'm not reading the entire paragraph on RP 158, paragraph 3, but the judge seemed to be reasoning that because the doctor did not go in and affirmatively say, before you say anything, you have a physician-patient privilege, that the doctor's failure to advise the defendant of that made her an agent. There's several problems with that. That's not the test that Santiago provides. Santiago, of course, is the case. This court, 2009 NMSC 45 says, it's A, whether the government knew of and acquiesced in the conduct, but 2, whether the party performing the search intended to assist law enforcement efforts or to further his own ends. And Santiago makes it crystal clear in paragraph 24. It makes it clear that if it's a mixed motive, that's not enough. So in other words, even if the doctor was thinking, I do want to help the police, but I'm also concerned because I'm the doctor, I'm in charge of the ER, it's 2 o'clock in the morning, they're going to be Artesia General Hospital Board of Directors to answer to. I need to find out what's going on. I also need to find out how it impacts her care, because one thing that's clear from the video is the doctor throughout all this made it clear your care is paramount. Even Sergeant Anaya says the number 1 priority is your care. We're going to step out if we need to, and the number 1 priority is your care. There's no evidence in the record that that the doctor was motivated solely to help the police.
Wait a minute. This girl goes into the emergency room. She's got these backaches. She's asked, "Are you pregnant?" She says no. They then do a pregnancy test. It comes out positive. They don't tell her. They don't tell her that the test shows she's pregnant. After the baby is delivered in the bathroom. So she comes in and says, "We found the dead baby in the bathroom." Worse to that effect. It gives weight to the assertion that they thought from the beginning, the doctor thought from the beginning, she lied when she said she wasn't pregnant. And now she's confronting her without the benefit of having given her any medical information. That she in fact delivered a dead baby. So that seems to me
the justice and the guy that guy's the one that keeps like kind of tells you where he's gonna land with this, okay?
pretty agency oriented in terms of assisting the police.
Well, again, Santiago says that it has to be solely to help the police. Santiago says that there's any kind of mixed motive, like you have a professional interest.
An inference can be made, it is solely to help the police.
I don't believe that inference can be made under Santiago, but I will say this, Justice, and I think this points to a good point. Even if you give the defendant the benefit of the doubt that she did not know she was pregnant, immediately upon giving birth, the natural thing you would think anybody would do is, help, help, I just had a baby, help, help, I need help. She did not tell anybody for 30 minutes. It was 30 minutes later that the cleaning lady found the baby. And obviously enough.
The cleaning lady found the baby, guys. She didn't yell out for help, help. Okay? She walked with the doctor back to the room. It's a very, very sad situation to watch that footage.
5-10 minutes till the police showed up. I think one can make a good argument that she did not even from the beginning avail herself of the physician-patient privilege. State v. Roper, 1996 NMCA 73, paragraph 6, said the privilege is designed to encourage patients to make complete disclosures of symptoms. I would argue that if you're hiding a material fact from the doctor that you just gave birth to a baby, you're not asking for help, arguably you're not even availing yourself for a privilege. Now, I understand after the fact, now that she's caught and she's in trouble, she wants to say, my privilege was violated. But State v. Strouds, 2015 NMSC 9, paragraph 44, states expressly, privileges often have limits, particularly where there are conflicting interests that may outweigh the interest of confidentiality. And it's interesting that Strouds notes...
And by the way, the bathroom had one of those poles. You know, like those poles that they have in the bathrooms in the hospitals? Like if you need help in the bathroom, she could have pulled that too. Nothing.
Paragraphs 29 to 31, that New Mexico in 1973 became one of the earliest states in the country to impose a mandatory reporting duty on all persons. So New Mexico has a rich history of protecting children and babies. And the other one more thing I wanted to note is it's also interesting that some of this privacy and privilege is a little bit pick and choose what serves me. There was a lot of emphasis in the answer brief about privacy and privacy. And they didn't respect her privacy. And yet there's something in the answer brief where they say, well, the hospital let her go to the bathroom unattended. Well, she's 19 years old. It's ludicrous, almost incredible to me that they expected the doctor to go into the bathroom or a nurse to go into the bathroom and stand over her to make sure she didn't do anything. So there's got to be some treatment of, you're 19 years old, you're a responsible adult. I think that's been a little lacking here in terms of the defendant certainly has rights, she's on trial, but there has to be something said for the baby's rights too.
Thomas, anything else? Any other questions? All right, thank you.
Thank you.
In the matter of S1SC 40478, the court appreciates the briefing and oral argument today. This matter will be taken under advisement and is deemed submitted. Court is in recess.
It's in recess. Oh, y'all stand up. Y'all sit down. Wait, do we stand up? We stand up when they leave the room. Sorry. I'm standing up anyways. Y'all let me know what you guys think in the comments. Okay. It is getting late. I've been streaming a lot today. And I wanted to have a reaction with you guys. And I wanted to see what you guys thought. When are they going to make a decision? Oh, look at, they put the face. Oh, see, I think that's Alexie's lawyer right there. Hold up. That's Colonel Sanders.
C4047.
Colonel Sanders was in the courtroom. I'll show you guys. Hold up. He was in the courtroom. I missed it. Hold up. 1 second. I'm gonna. Then they face the camera to the people. Look at. He's right there. Colonel Sanders is right there. That's Lexi's lawyer. Okay. They're all there, man. Whew. Yes, I said Colonel Sanders. That was the running joke when we were covering this case in the summer and they had the hearings. Okay. Let me remove this. Y'all let me know what you guys think in the comments. Thank you for watching this with me and reacting. I love you. The fact that you guys were there. I know it's a very heated conversation and debate, but that case is a very heated conversation and debate to a certain degree. But let me know what you guys think. I'm going to go to bed. I'm tired, y'all. I got to go tend to baby bunny. We've been live a lot today. Please, tomorrow I'm dropping. I got a couple more edits. I think I'll be done tomorrow officially, but I am dropping my To Catch the Predator video tomorrow, so please don't miss it. Y'all do me a favor, hit the like button, support the channel, share. If you were wondering who was going to cover the Alexee Trevizo thing, this is the channel. So I know a lot of people, especially on the Reddit, they were asking, who's talking about this right now? It was us. So make sure you guys share it. All right, I'll see you guys tomorrow, but let me know what you guys think in the comments. Bye, guys. Bye, bye, bye.